Okay, welcome everybody. Good to be here. I've been absent a little bit for the last couple of weeks, taking some vacations, and so has my colleague Lane. So I got a lot to share with you today. I'm looking forward to it. Excited to have Lane Martinsen with us. Lane is a financial advisor. We'll talk all about that today, but he's got quite the YouTube presence as well. Hundreds of thousands of subscribers, tens of millions of views. So we got a lot to share. First thing I want to do just real quick, and then we'll jump into the meat of estate planning and wealth management and how they intersect, and some important things you can be aware of as you work to get and keep your affairs in order. I want to give you a couple of quick introductions for those of you who haven't seen or been on either Lane's or my channel over the last few years. So quick introduction for me. My name is Paul Rabalais. I've been an estate planning attorney since 1991. Education-wise, I went to school in Louisiana, LSU Law School. After law school, went up and earned my master's degree in tax law from Boston University's law school. Came back down, worked for some big law firms for about 4 or 5 years. 25 years ago or so, started my own law firm. I've helped thousands, maybe even tens of thousands of people get and keep their estate legal affairs in order. We'll talk about some of those strategies as we go along today, but excited to be here, and I'm going to turn it over to Lane to give a quick introduction of yourself. Welcome, Lane.
Yeah, thank you, Paul. Lane Martinsen. I am the CEO and founder of Martinsen Wealth Management, and we service clients all around the country. We have a team of financial professionals, and we absolutely love what we do. Been in the industry for a very long time. And we are what we would call holistic planners, fiduciary, holistic, comprehensive planners. And we really specialize in retirement income planning. We do a lot with taxes and really looking at the whole plan. And it certainly includes estate planning. So
and I hear that word a lot, holistic, in your industry. And so yeah, as you know, being the estate planner, if your emphasis is on the retirement income planning, certainly appears to me like, you're helping people in those age groups of 60s and 70s. And those are the people who seem to be, even though people procrastinate with estate planning, those people who are retiring, they're in their 60s, they're in their early 70s. They get to a point in their life where they realize, hey, I'm not going to live forever. I've accumulated some assets. I have a family. It's important that I secure this legacy and pass things along the right way. So at what point, or just when, do your prospective clients and your clients, if ever, do you find them bringing up as part of the retirement income planning conversation? Do you find them bringing up the estate planning piece, or is it more often where you bring it up as part of your holistic service that you provide?
Yeah, we always bring it up. So we have a very specific planning process, and we check things off as we go through, make sure that everything has been considered. Estate planning is always, a critical piece to make sure. Beneficiary designations, there's, so many rules that have changed. The Secure Act just changed, but what's an eligible beneficiary for a qualified account, and the 10-year rule, the 5-year rule. So there's been a lot of changes. So it's kind of a moving target. It's difficult for people to really stay on top of that. And so we want to make sure that they have a good plan.
And so when you ask them if they have a plan in place, I'm sure some people will say yes, some people will say no, and some people will say yes, but, and the yes, but is, yes, but I did it 25 years ago, or yes, but it needs updating. What kinds of things, when you start that conversation, I'm wondering what kinds of issues they're bringing up. Is it, I want to take care of my spouse, I want to make sure my kids are taken care of, I'm scared to death, Lane, about the taxes, my children can't handle money, I have a business. What are the typical estate planning issues, just at a high level, that people mention to you when you bring that conversation up?
Yeah, I mean, it's kind of all of those things, but there's a lot of people who just kind of put it off and put it off, and they actually haven't really done it, or they did something so long ago that's outdated, right? And they're kind of like, well, I think I've got will, or, they don't even hardly remember what they have. And so it's kind of dusting off and let's take a look and see what you've got. But most of it is fairly, you can get really sophisticated with large estates. Most of what we're doing is just making sure, we're looking at taxes. We're looking at making sure their wishes are done. Want to make sure they've got all the powers of attorney and all the living, the living will, all those documents in place. Because it can be, as you know, it can be a disaster if they don't have them, right?
Yeah, and I'm a big preacher of financial advisors and estate planning attorneys working together to make sure the mutual clients' needs are served. And so there's a lot of advisors out there, they never have even thought of touching the estate planning piece. And so I'd love to get some feedback from you on, because I know over the years you told me, Lane, that you have been providing, you taking action to make sure that your clients' estate planning needs are met. When you do that, is the client kind of surprised that you brought that up, or they expected it? And then once you do it, do you feel like it enhances that relationship that you have with your client, and kind of, does the client appreciate you're helping them through that, or is it something they expect? I'm just trying to get what's your what's some of the benefits to you and the client, and what are you seeing happen when you do take that active role in making sure their estate planning needs are met?
Yeah, well, they realize that, we're serious about being comprehensive and looking at the whole plan. And frankly, people aren't accustomed to that, right? Traditional kind of investment advisors, they kind of have blinders on. They just want to look at and talk investments, and anything else, is not their responsibility. And so we have a very different approach. We really want to see the full thing. We're going to be asking people for their tax returns. We're going to be doing a lot of tax planning, as well as the estate planning, along with the investment. And so healthcare is also a big part of it, long-term care. When you think of all the things that you face, especially in retirement, good planning can save you a ton of money down the road, and you can create efficiencies. Your money can actually grow better because you're not wasting money unnecessarily. And so that's what we strive to do. Estate planning is a huge part of that.
Yeah, awesome. All right, well, I want to jump into just give our viewers maybe a quick 3-minute overview of estate planning, and then I'm going to turn it over to you, Lane, to give a quick overview of kind of what your service looks like. So from my end, as the estate planning attorney, I think a lot of people out there in the public, when they hear estate planning, they think of getting a will done. So there's so much more to it than just, quite frankly, getting a will done. And so when I approach estate planning with someone, I always want to see what's going on in their mind and in their heart about what they'd like to accomplish from an estate planning perspective. And look, some people say, Paul, I don't know what I don't know, so you've got to guide me through this. But many people have certain objectives. If I can kind of pull it out of them, they'll start to tell me what some of those objectives are, which might be anywhere from, I want to make sure that if I pass away, my spouse has no legal issues to deal with. I want to make things easy for my spouse. Some people say, I don't want to leave things to my kids a certain way. I have different children with different needs, and so I want to make sure each of my children's needs are met. I want to be fair, and sometimes fair and equal is the same, and sometimes fair is something different than equal. So we tend to pull that out of them. We talk about, sometimes people say, I want to make sure that this child or these children will have the ability to easily handle my money, handle my business if I either pass away, or if during my lifetime I'm unable to handle things for myself. So making all those property, trustee, executor, power of attorney, healthcare designations are really important to some people. Some people tell me, Paul, I just want to make sure my estate doesn't get eaten up with taxes. We may talk in detail about some of the specific tax provisions: income tax, capital gains tax, estate tax, step up in basis. A little later on, retirement. By the way, you mentioned the Secure Act. I know that there were some final regulations issued just in the last couple of weeks. And so that's a big new piece of estate planning with those distributions from traditional IRAs and 401ks and how frequently the taxes need to be paid. We got some new rules there. So
Yeah.
my job as an estate planning attorney is to really ask questions, ask the right questions, and then listen to those answers so that I can ask the next right question, and then put together a kind of a start to finish plan of, okay, this is exactly what you wanted to accomplish. You wanted to keep your family out of court. You wanted to avoid all the probate. You wanted to avoid or minimize the taxes to the extent that you can. You want to provide for your spouse this way, provide for your children this way, put these people in charge of this, those people in charge of that. Here's the plan to do it. And then, if the client says that sounds perfect, then we get to work, preparing all of the things that we need to prepare. And that starts often with trusts or living trusts or other types of trusts, wills, powers of attorney, healthcare documents, transfer documents, sometimes when people are transferring assets to trust. So the big work of the estate planning attorney is really in the building and the making of the plan, and then doing the appropriate execution to put that plan in place. And then for years after, it's just kind of keeping an eye on things in the event there are major changes in family circumstances. Sometimes that does require amendments and updates to estate plans. So it's a little bit about what we do, and could go on for hours, but let me turn it over to you, Lane, and kind of talk about your process. In particular, maybe touch on the estate planning piece as well.
Yeah. So I guess what I'd start with is an analogy of, if you're building a house and you're gonna have a general contractor, right? And the general contractor uses subcontractors who specialize in various areas. And a financial advisor, financial planner like us, we always have to work with estate planning attorneys, right? Because you are the only ones who can draft documents, legal documents. That's not something we can do. But we act a little bit more in our role as a general contractor, saying, okay, we need to sub this out. We need an expert in this field. And same things, sometimes we'll pull in a CPA, we'll pull in some other experts, but we're looking at a whole plan. So that's definitely our approach. And what I find, or what I have found, is a lot of people don't like to think about estate planning. It's just it's so easy to put off, right? Because there's just a million other things you'd rather be doing. It's not that fun to think about end of life stuff. It's just kind of a chore that's like, oh yeah, I can get to that. And what we have found is when we show people, like, hey, this actually isn't going to take too long. You're just going to bite the bullet, make some decisions. Let's get all the things in place. And then you can kind of rest, right? You can have some peace of mind, feeling good about what you've got in place. And another thing that I always tell our clients is that estate planning it's really kind of an act of love, right? It's really caring for your family, because so many family relations can just be damaged that were great before, and then a death of a parent or something, and all of a sudden there's this big wedge, miscommunication, misunderstandings that can just all be avoided, let alone the costly probate and all the other things that could go into it. But why not simplify your family's life by just making some decisions, get the documents in place.
Yeah. And I find that, well, you're right. It is easy to procrastinate, and many people do, and can't fault them for that. It's just natural.
Yeah.
I find that, at least as I have those conversations, I start seeing kind of the shoulders just drop, where as we go through those conversations, they're like, wow, I feel so much better having at least just started the process by having the conversation. So I think a lot of it depends on who's leading that client through the process. I've had a lot of people tell me, Paul, I went to a lawyer. It was a disaster. They were talking over my head. I didn't understand a word they said. They just sat there and talked the whole time. And so it happens with lawyers and with financial advisors alike. So I think making sure you have the right help is a key aspect of of getting things done to your satisfaction. So, but I do want to turn to, because the two of us are on this video, I'm very excited about how, and I think the financial advisor industry can really has an opportunity to take advantage of enhancing relationships with clients and getting more referrals from clients by making sure that the services of the estate planning attorney and the financial advisor complement each other. I want to talk about that for a minute. So, I'm going to do it by telling a story because I'm involved in an estate settlement right now where a daughter, after her mother passed away, the daughter came to me and the daughter said, Paul, about 6 months before my mother passed away, my mother knew she was passing away. She was sick. My mother told me that due to the fact that the mother had no contact with the son for the previous 5 years, the mother wanted to change her estate planning documents to have all of her money go to the daughter. And the daughter, of course, was caring for the mother, was caring for her every day, was caring for her while she was sick. And the daughter was, of course, Mom, you do whatever you want to do. It's your decision. And I'll support you, whatever you want to do. So anyway, Mom went to the lawyer, changed the will, changed the trust. I leave everything to my daughter. I'm excluding my son. And the mother had a financial advisor, but the financial advisor was never made aware of mother's intentions.
Yeah.
And over half of Mom's money was in Mom's IRA. And so Mom passed away. Financial advisor had no idea that Mom had changed her estate planning documents. And sure, all of the kind of non-pro or probate assets or trust assets went to the daughter, just like Mom wanted. But there was almost $1 million IRA that still, because the beneficiaries still went 50-50 to each of the two children, it just did not go how Mom had intended. Mom's probably rolling over in her grave. No disrespect to Mom right now, but that was a clear example of how, if the financial advisor was just a part of the conversation in what Mom wanted to do, then the financial advisor would have said, sounds great, Mom, I'm here to help you. But not only do you need to change all of your estate legal documents, but we also need to change this beneficiary designation on this IRA. And now, of course, there's a feud between the two children who were left behind. So looking at it the other way, I really get excited when someone contacts me and says, Paul, I need your help putting my estate in order. I'll likely ask the question, do you have a financial advisor? And oftentimes they'll say yes. I was like, well, do you want them to be a part of the conversation? And just like we're having this on Zoom, we can get that financial advisor at a minimum just to be a fly on the wall in the estate planning conversation that I lead. If not, the financial advisor can even play a greater role, because that by the time they get to me, they're probably 65 years old or 60 years old, and they may have had a relationship with their financial advisors maybe for the past 10 years or more. And so that financial advisor knows the client better than I know the client. I'm going to have 1 hour meeting with the client to design their plan. And if that financial advisor is part of the conversation, whether it's Zoom or otherwise, sometimes the financial advisor can say, hey, client, 6 months ago, you told me that you wanted to pass along your business to your son this way or to your daughter that way. Or, 9 months ago, you told me that you wanted to set something aside for your grandchildren's education. And they can often provide some serious value to the estate planning process. So I always, and I realize some lawyers like to do it all themselves, but I really get excited, and I'm really trying to put out a lot of content encouraging those advisors and clients and attorneys to make sure that that holistic advisor who is actively engaged with the client becomes part of the estate planning process. So, as you say, things don't get missed, and because it is the advisor who, like I said earlier, controls the beneficiary designations, which are critical. Some people out there, they think if they say, and they should never say this, but they think if they say in their will or trust, I want my IRA to go to child A and child B, That has no validity whatsoever. The IRA is going to go to whoever's named as the beneficiary on the financial institution's beneficiary designation form. So if the beneficiary designation form says I want my IRA to be split equally between child A, B, C, and D, that's how it's going to go. Even if in the will they said I want my IRA to go to A and B. So the financial advisor has all of the control over the beneficiary designations, the TOD designations. Account titling is a big deal. I'm gonna get off. I'm gonna quit yapping so much here in a minute, Lane, and let you chime in. But people often ask me, Paul, what's the biggest disadvantage of creating a living trust? And for those of you who have watched a few of me and Lane's videos, we know that it's really common for people and families to want to avoid the court and attorney involved probate process by setting up their living trust, transferring assets to their living trust. Because when they pass away, assets that are already titled in their living trust avoid the court and attorney involved probate process. So many people set up their living trust, but they either make the mistake or it gets neglected. They don't retitle their brokerage accounts and other assets into their trust. That's the second piece of this living trust planning. One is creating it, and two is funding it or transferring assets to a trust. So I've handled many probates where someone set up a living trust, but for any number of reasons, it could be at the fault of the client, the attorney, the advisor. Usually it's kind of a combination of many factors. Maybe the client opened up an account after creating their trust and kind of forgot to title it in the name of their trust. But many people, one of their main objectives of setting up an estate plan is to enable their family to avoid probate. And when the advisor is not involved because the advisor is not aware, the advisor is not able to help that client retitle that investment account into the trust, and then the probate's necessary when the client passes away. So many reasons for the estate planning attorney and the financial advisor to work together to accomplish that client's estate planning needs. So anyway, that's a quick version from my end. Maybe Lane, you can maybe add a piece of what your thoughts are on how your role gets affected by all of that.
Yeah, we feel, a lot of responsibility to check beneficiary designations and verify, and for sure. A question I have for you, when it comes to someone with a living trust, and whether it's retitling accounts into the trust or simply using the trust as a designated beneficiary, right, or as the beneficiary, because some accounts can't be retitled, right? Retirement accounts, IRAs, 401ks. And so maybe you can share some thoughts, pros and cons, of when you would use a trust as a beneficiary or a contingent beneficiary versus retitling the name of the account.
Yeah, so I'm going to break that answer down into two different parts. One, what to do with retirement accounts, like you say, IRAs, 401ks, especially traditional where the income tax hasn't been paid. And then what to do with like the brokerage accounts.
Yeah.
So the trickier one is the IRAs and the 401ks where income tax has not been paid. My general rule, and I don't know if it's anybody else's general rule, I kind of think it should be, but my general rule is if we can avoid naming a trust as a beneficiary of a traditional IRA, we do it. So if we can accomplish all of the client's goals, and look, maybe they want to name their spouse as their primary beneficiary and their children as the contingent beneficiaries. That's what most people typically do.
Yeah.
And they don't have any kind of I don't want my children to get it all at once issues. There's no need to have a trust manage the asset after the IRA owner passes away. My general rule is when we can get away with it, I like to name individuals as beneficiaries, just because when you name a trust as a beneficiary, everybody gets confused and everybody gets scared. The beneficiaries don't know what to do. The Attorneys often don't know what to do. The advisors don't know what to do. The financial institutions don't know what to do. Heck, just about 10 days ago, we came out with new rules on what's the income tax consequences of inheriting an IRA. Kind of the big one being is if the IRA owner had passed his required beginning date, started taking distributions, then those beneficiaries are going to have to take required distributions over that 10-year period and then take the rest of it at the end of it. There was a lot of unknowns just 10 days ago on how all of that worked. The rules were not clear.
Right.
So the rules are changing, and that's just one example of how everybody gets confused when you name a trust as a beneficiary. So that's my first rule on IRAs and 401ks. Name individuals if you can, but if you need to use a trust to provide for the ongoing management of that asset, then we have to look at the income tax consequences. When do distributions have to be made? And if you do designate a trust as a beneficiary of an IRA, is it what the IRS refers to as a conduit trust, or is it an accumulation trust? When it's an accumulation trust, there may be additional income taxes paid because those distributions accumulate in a trust, and then the trust pays the income tax at higher trust income tax rates. So again, part of the complication there. So that's my quick version of should you name individuals or trusts as beneficiaries of a retirement account. If you have a brokerage account, then it seems like the main decision is, and really it can be done either way. Do we retitle our brokerage account to our trust, or do we just simply name it as some type of TOD beneficiary, name the trust as the beneficiary, or do you name individuals as beneficiaries? So there's three options there. If there's the need for continued management of that brokerage account after the brokerage account owner passes away, then yeah, you'll either have to retitle that account into your trust or just simply name the trust as a TOD beneficiary. Really, either one of those works fine. So is that starting to answer some of your questions there?
Yeah. I mean, that's right along with what my thinking was. I was curious to see what your thoughts were on that.
Yeah, the tricky one is when you have, it doesn't have to be a blended family. But, and I'm going to speak bluntly here, let's say, husband has his $2 million IRA, and he likes the idea of leaving assets to a trust for the benefit of his surviving spouse, but also making sure that when the surviving spouse later passes away, those assets revert back to his children, really preventing those assets from going to his surviving spouse's next spouse or someone who may influence his surviving spouse into doing something that kind of isn't part of the plan now.
Right.
That gets real tricky when you have an IRA, because if you name, and the lingo for it is a Q-tip trust, but it's a trust that, for your spouse, and then when your spouse dies, it's typically for your children. When you name a trust for your spouse as the beneficiary of the IRA, that surviving spouse is going to have to take required minimum distributions. And if that surviving spouse lives long enough, they're going to deplete the entire trust, preserving nothing for the children to get when the surviving spouse dies. So even when you have those married person situations where they're like, I want to leave my IRA to my spouse, but I want to make sure my children wind up with something. Sometimes in those circumstances, the client will guide the client through instead of using a trust that might get depleted during the surviving spouse's lifetime, leaving nothing for the children. Sometimes that person, especially if it's a second spouse, they'll say, well, I'm going to leave my second spouse 50% of my IRA. I've got 2 children. I'll leave them 25% each when I pass away. That way I know my children will get something. And then if my surviving spouse lives for a long time and, takes all those required minimum distributions, at least I'll know my children have received something. So you have to be really careful with the IRAs, particularly in a second marriage situation, because sometimes, even though the documents may indicate that the children will get the assets when the surviving spouse dies, the required minimum distribution rules often permit that inherited IRA to be depleted due to RMDs to the surviving spouse. All right, so have you messed with that much at all, Lane?
No, I mean, we see that, yeah.
Yeah.
Let me follow up with a question. A beneficiary designation is of high, what's the word? It precedes or is of higher status than a document, than a trust, right? Can you just maybe speak to that so that that's understood? I think people don't, a lot of times I think people think they have a trust, the trust controls everything, but if they've got beneficiary designations, they will trump.
Right.
Right. Yeah.
Right. So yeah, there is a lot of misconceptions out there. So many people do set up their living trust to enable the assets when they die to avoid all the probate process. And they transfer their assets to their trust during their lifetime. And sure enough, when they die, those trust assets get distributed to the trust beneficiaries. And in that trust instrument, it says when the person who created the trust dies, the trust assets are to go to these people in the proper proportions. But an IRA, while the IRA owner is alive, an IRA can't be titled in the name of a trust. It has to remain in the name of the individual. Typically, it's the individual who was the employee for a company when they had a 401k, they retired, they rolled their 401k into an IRA. So an IRA is always in an individual's name. And I used the example earlier where someone in their trust, or if they didn't have a trust in their will, they said, I want my IRA account number 1234567 to go to Jack when I die. It's very clear. It's in there. No ambiguity whatsoever. It's in the will and it's in the trust. However, when that IRA owner dies, the will and the trust have nothing to do with where that IRA goes. Right. That IRA is a contract. And when the person set up their IRA account, as you know, Lane, they also were able to designate and did designate beneficiaries. Who's going to get the IRA when the IRA owner dies? And that paperwork was done through Schwab or Fidelity or LPL or wherever the IRA account is held. And when that IRA owner dies, regardless of what the will or trust says, that financial institution is going to pay out that IRA to whoever is on the beneficiary designation form with that financial institution. And it's not ambiguous. There's no gray area. The person can say, but I put it in my will. I wanted it to go to this person. It will not go to whoever is designated in the will or trust unless the IRA owner said, I want the IRA payable to my trust or to my estate. And then it will run through the trust or will run through estate. But there could be some negative income tax consequences to naming an estate as a beneficiary of an IRA because that's subject to the 5-year rule instead of the 10-year rule and a bunch of stuff we don't need to get into. So yeah, if people take away one thing from this this live stream here is, for many people, as you know, Lane, their IRA is their largest financial asset, and because of that, the beneficiary designation, the preparation, the filling out of the beneficiary designation can be just as important, if not more important, than the creation of their will or trust. So, yep, a lot of mistakes being made there. Hopefully, we can help people clear some of that up.
Yeah, yeah. Well, Paul, maybe what questions would you have, maybe for a financial advisor, financial planner, what we do, from your perspective, as you look at financial advisors?
Well, I'd even though your process, it doesn't involve me. We just met recently. I'd love for the advisors in our country who are helping people who are not engaging in really providing any assistance in estate planning. And look, I realize advisors, they have the checkoff question of, they ask their clients, do you have a will? Do you have a trust? But that's not really helping clients get through the process. And when we first spoke, Lane, you talked about the process of how you help the clients get through estate planning. And I want other advisors to realize they can start having more in-depth conversations about estate planning with their clients. So I'd love for you to just kind of share what you've done over the years, what has worked well when you have played a role in the estate planning. You can provide as much detail or as little as you want to about service providers that have helped you, but just generally what kind of what your role has been, so that other advisors can feel confident in starting to have those conversations as well.
Yeah. Well, we have relationships with estate planning attorneys, and many of the attorneys are, licensed only in one state, right? And we have clients all around the country, and so we have some different relationships depending on where people are living. But the process for us is kind of a 30,000-foot views, like, what have you got as far as your estate planning? Have you thought through it? Do you have all the documents? And then if there's a need there, then we're going to, bring in or refer to an estate planning attorney such as yourself, who specializes in that, can address their questions. And what we've done is, with some of the firms that we've worked with in the past, is we'll kind of do a initial questionnaire and assessment that we will provide to the firm, so that it kind of saves them some time. And then they have their meeting and do their work. And then after the documents are all drafted, questions are all answered, they will send the documents back to us to take, that next step off of the attorney's plate. Meaning, so we will actually help our clients with the witnessing, the notarizing, all of that, and then helping them to fund the trust if they have a trust.
Yeah, fantastic.
Yeah, and that's a big piece. And one thing most everyone wants to do is get their real estate into properly set up with the trust, so that will avoid probate. And so we go through the process of helping them know how to do that with, changing the deed, or, making sure that's all done properly. So that's kind of how we do it. We just, it's a piece. We just want to make sure it's addressed. We've got the appropriate expert to make sure it's done, and then we help kind of finish it off. So that's how it works with us. Because we're looking at so many different aspects of their plan, and investments and insurance and healthcare issues, all of those things we're looking at and we're dealing with, and so.
Yeah. And let me jump away from the estate planning and a little bit from a selfish perspective. I at least think about retirement every day. I don't know when it'll happen, but what's that? And look, there's all kinds of calculators. I see them online. So tell me a little bit about, if somebody comes to you and says, "Hey, Lane, I'm 60. I've got, 1.5 in my retirement account. I've got another $1 million in a brokerage account, and I know I'm going to get Social Security in a few years. I may keep working a little bit." There's all the Monte Carlo projection stuff out there. What's unique about your kind of pure retirement income planning process that you use?
Yeah, that's a great question. So I actually wrote a book about 5 years ago. It's called The Holistic Retirement Planning Revolution. We're actually within a couple of months doing an updated version of that. It's going to be called the 5W Retirement Blueprint. 5W, the 5 is the 5 key areas of wealth. One of those is estate planning, but it includes income planning, investment planning, tax planning, healthcare, longevity, and then estate planning. And so in there, if you think of traditional financial planning or investment advisory firms, like I said, they're for the most part, they're focused on investments, right? There's so many issues that get ignored. And I refer to it as traditional planning or traditional asset allocation, for example. And, there's the old rule of thumbs. There's using Monte Carlo simulations. Am I going to run out of money? To us, that's very kind of old school. And
Is like the 4% rule, is that part of old school stuff?
it's old school, yeah. Because I mean, it's an important, it's one of the things we can look at. But you can now have guaranteed sources of income. A lot of people wish they had a pension, but you can actually have a private pension, right? So you can have guaranteed lifetime income. You can have some guaranteed growth from certain types of annuity products, for example, as kind of a baseline, and then you have your investments. And so in the book, I refer to it as green tools and red tools. You have the investment firms or advisors. I refer to them as red tools only, financial tools or red tools. Then we have green tools, and those are typically going to be insurance-based type products, life insurance, annuities. And you tend to have, the licensing is different, the regulations are different. And so you tend to have these two camps, right? On one hand, they kind of think one way, and then in the other camp, they think entirely different. And which is better? And the truth is, they both have pros, they both have cons. They both have their strengths and weaknesses. And so as a holistic fiduciary, we say, well, let's have all the tools in the toolbox. And then, what's the best combination of the tools to build a plan that's stable, reliable? It's going to include some red for sure. It's going to include some green. It's going to include a lot of tax planning. It's a big area that gets ignored because you have people who have been, doing what they were told to do, and that was to contribute into company plans, 401ks,
Right.
tax deferred until retirement, and then they realize, oh, wait, I've got a tax problem here because everything's tax deferred until retirement, and tax rates are likely to be up, and so we look at what if you leave your assets in a tax deferred account versus a multi-year Roth conversion plan, for example, and we get some of that money shifted, and then we look at the outcomes over a retirement plan, and it's significant, right? Significant savings, because when you have money in a tax deferred account and the money's growing, right? You're getting some interest, some rate of return. It's a piece of that is always going to the government, right? So you kind of year after year, you have compound taxes forever. And so when you can get some of that shifted, or the right amount shifted over time to tax free, then you're no longer in a compounding tax environment, and then you put some time to that, and it's a significant savings over time. And so we love doing that kind of planning. But tax planning is huge, investment planning, insurance planning, estate planning, and when you put that all together, it really makes a much more just a more efficient plan, more predictable
Yep.
plan.
Yep. Let me ask you this, since we've both been building our YouTube channels and we're pretty darn close in numbers as far as subscribers and that kind of thing. But I'm wondering if like your YouTube channel, and this is more of a kind of sharing some information for all those other attorneys and financial advisors and professionals who are considering, making content to put out there on social media. I can tell you from my end, it's been a life-changing experience for me. Started it about 8 years ago, and kind of about 4 years ago it took off. And we were getting requests from people all over the country with significant wealth. Very, very fortunate to help lots of people. You mentioned earlier, your clients are around the country. What has been that impact to you personally and your business with your successful YouTube channel?
Yeah, it's been a huge, it's been really good for us. Yeah, I mean, we do a lot of Social Security planning. Social Security is very complex, and so we have quite a few videos out on Social Security strategies, and they've been viewed, in the millions by millions of people. And so and we have a Social Security report that's a real low cost that we offer, and it's been good. I mean, we have really great people that they find us on YouTube. They go to our website. They schedule a free consultation.
Yeah, same here.
We connect through Zoom. It's very easy and nowadays, and so it's been a blessing. It's been a lot of fun.
Yeah, really has been. Yeah, like anything else, it requires work. But
It does
but
require
yeah,
work, for sure.
I find it really makes the professional a better professional because by putting content on social media, you're forced to better understand concepts, explain them in a way that people can understand them. So it really forces you to be a better professional when you make that content for the public out there. Let me hit a few of these questions. I see we've got a bunch here. Let me just, as always, hello to Larry. Got Ann here and got Larry saying hello to Ann. So that's good stuff. Larry's telling people hit the like button. Couldn't agree with you, Larry, more. Let's see. Okay, and so Larry, it looks like Larry, no, that's LD, LD and an LJ. So Larry is becoming a Maryland resident. Fantastic. Not Larry, LJ. LJ, New Hampshire is fully repealing state income tax next year. So yeah, a few states, the big death tax that's out there is the federal estate tax. Doesn't affect many people. In fact, for people who pass away in 2024, the first $13.61 million of assets is exempt. That exemption is scheduled to be cut in half in a couple of years.
Yeah.
That applies to everybody, no matter where you live. A few states have their own either estate tax that taxes estates or inheritance tax that taxes the recipient of an inheritance. And according to LJ, New Hampshire is fully repealing their state income tax. Okay, fantastic. Let's see. My problem is I can ask the same question to 3 different estate planning attorneys and I get 3 different answers. There you go. Welcome to my world. Okay. Thanks, LJ. Paul is the best estate planning YouTube channel in the United States. Thank you. Thank you, LJ. Is a revocable trust a one payment or monthly payment to keep? I'm not sure what you're asking there. Maybe I'm answering your question. It's something that you typically incur an attorney's fee or a fee to get your trust established and funded. And then so long as you're the trustee or there are individual trustees, there's no real ongoing or monthly or annual expense to keep that going. Let's see. Well said, Lane. I've seen it happen twice where people blew off taking action and they were dead the very next week. That's what my lawyer did. So make sure kept in touch. So make sure, yeah, and says make sure the financial advisor is kept in touch, of course. Listen to Paul, people. My family has been through 2 will contest litigations. Yep, those are a mess. My favorite story is when Dad died. He owned 30 or 40 pieces of industrial property, and he left everything to his 4 children. And his 4 children didn't get along at all, and he named his 4 children as co-executors. I knew it was going to be bad when I heard that each of the 4 children had their own security guard at Dad's funeral to protect themselves from their siblings.
Wow.
And it got worse from there. So, yeah, it can be a mess. Probably Dad's biggest mistake was naming all 4 children as co-executors, 30 pieces of industrial property to pay a light bill on one of them required that all 4 of them sign off on the check as co-executors. Just a big mess.
Yeah.
Let's see. Lots of just great comments in the chat. Just not still me 2 children also be the beneficiaries. Great content. Jenny Justice says I will look at the Social Security planning video. Since Jenny, you said that, what's the website she could go to, Lane, to check that out?
Well, the YouTube channel is just the Financial Fast Lane. We're Financial Fast Lane.
Yep.
And
all right. Very good. And got somebody apologizing for the typos. All good stuff. Okay, so as I start to wrap up here, thousands of people have said, get your estate legal affairs in order. Thousands of people, if not millions of people, have said, work with a professional to make sure that your wealth is managed appropriately. But very few people out there are saying, if you are using the services of an advisor, and you're going to need an estate planning attorney to get your estate legal affairs in order, consider strongly working with both of them. Even if your advisor says, no, that's just, I don't do that. I just handle the investments. You may have a great relationship with your financial advisor and you may have had some discussions about estate planning. I encourage you and from whether you're an advisor or you're a consumer with an advisor, get all those heads together and make sure nothing gets missed, make sure things go exactly how you'd want them to go. So that's kind of my piece is take advantage of those services. I think most advisors want to be engaged in the estate planning piece. They're just not sure how to do it or not sure if the client would want it, but the client always wants it and appreciates it. So that's kind of my thoughts. Anything you want to add to that, Lane?
No, I don't think so. I mean, it's been really great to talk to you, and you're a true professional, and it's you play a very important role, and it takes the right team, I think, to really pull things together. It's not normal to have a cohesive team or typical, right? What is much more typical is what I call a la carte financial advice, right? So, you talk to someone over here, but they don't really know the whole picture. And so it creates problems, it creates inefficiencies. And so that comprehensive whole plan, there's just a lot of value, quantifiable value that comes out of that. And so really appreciate you, Paul.
Yeah, well said. How do we get your book? Is it on Amazon or how do we get it?
It is. Yeah, it's on Amazon. Just if you search on my name, Lane Martinsen.
Okay.
Like
And
I
you've
said,
got a new edition coming up?
yeah, this thing's almost 5-6 years old. The new edition is literally a couple months, and so I'd probably watch for
I'm gonna
that.
hold out. I'm gonna hold out.
Yeah.
Yeah, I actually wrote a book on estate planning for people in my state, Louisiana. It's in its 4th edition, but it's long overdue. The 4th edition was published in 2016, so I've got to get to work updating that. We've had a lot of changes since then, but nice to be able to sit down and collect your thoughts and put them in a written format like that, organize them. Because as you know, me and you were having to answer questions, just pop, pop, pop. And it's really nice to be able to put it together in a book and see how it all fits together. So has that been your experience?
Yeah. Yeah. For years, I didn't see myself as a writer, right? And it felt like this overwhelming task to write a book, but I just felt like I had an important message. And so I just said, well, I'm just going to write one chapter. And I sat down, wrote the chapter, and then I just really got it going, and it turned out quite well. And so we've been really, really happy with it.
Yeah, I did it exactly the same way. I outlined about 12 chapters. I said, well, I don't know if I can write a book. Let me pick the one that I think would be the easiest chapter to write. And for me at the time, it was the chapter about living wills, which is that statement about life support machines. We had a statute. It was pretty easy to follow. So I wrote that one. And really, when I wrote that chapter, I just kind of wrote an introduction. Here's what I'm going to tell you in this chapter. And then I wrote it. And then I wrote a conclusion. Here's what I told you in this chapter. And then I went on to the next easiest chapter. And before I knew it, I had a book, and there it was. So, yeah. Okay. Well, look, I hope we can do this again sometime, Lane, and appreciate all the viewers on Lane's channel and my channel, and look forward to much more content being delivered by both of us. So y'all have a great evening.